Greetings, everyone. We are the Group 10, and our content for today is all about anti sexual harassment law. We'd be also be tackling about what sexual harassment is first. So today I am your first reporter, Jashane Tomado, and I will be tackling about the anti-harassment law and the sexual harassment itself. Next, please. Anti-harassment law. Gender equality is among the major policy goals included in the Millennium Development Goals, or the MDG, of the United Nations that it wishes to achieve by 2015. Apart from the MDG, various other international legal instruments and agreements were crafted even earlier to address the particular vulnerability of the women's sector. Next, please. Anti-Harassment Act of 1995, or the RA 7877. The impetus for the passage of the Anti-Sexual Harassment Act of 1995 was predicated on the overall global effort to address issues concerning women. It is a part of a bigger government program on gender equality subsumed under the Gender and Development, or the GAD, policy thrust of the government. While gender programs address as a whole the concerns of both men and women, these programs are initially tilted heavily in the direction of women's issues to address the hitherto existing inequality between women and men. Next, please. Sexual harassment is not primarily about sex, it is mainly about power. This underlying power equation is reflected in the definition of sexual harassment as provided for by the Republic Act itself. The key concept of sexual harassment is the lack of consent to perform sexual gestures and activities. And this may occur anywhere at any time, whether at work, school, or even at home. Sexual harassment could be simply as telling offensive sexual jokes, or as worse as touching someone against their will, or rape. Next, please. So now at this juncture, Section 3 will be reported by the next reporter.
Good day, everyone. I am Hayana Tahir, and I'm going to report about the Section 3 of the Republic Act 7877, or the Anti-Sexual Harassment Act of 1995. Next slide, please. Section 3. Work, education, or training related sexual harassment is committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who, having authority, influence, or moral ascendancy over another in a work or training or education environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted by the object of said act. So sa Section 3, iyang gina-imply is sexual harassment is not only limited in the four corners of our home, nor is it limited in the wide roads or the streets. Because ang sexual harassment, pwede po siya mahitabo in our work, in the school, or any other employment environment. Next slide, please. So naay mga conditions nga na-fall under this section. First, in a work-related or employment environment, sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual, or in granting said individual favorable compensation, terms of conditions, promotions, or privileges, or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee which in any way could discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. So this condition implies that ang sexual harassment daw is pwede daw siya mahitabo if ang mag-harass is mag-offer siya any trade or any compensation sa iyang victim, whether promotion siya or any other type of privileges nga i-offer niya sa victim to para i-accept lang sa victim ang iyang sexual favor. Or It can also be if mag-refuse ang victim, pwede po niya i-classify or i-segregate ang employee in any way nga ma-discriminate ang employee o ma-deprive or diminish iyang employment opportunities. Second, the above acts would impair the employee's right or privileges under existing labor laws. Of course, it would also degrade the privacy of the victim. So, if in any way dili madayon ang sexual harassment, if na-degrade nimo iyang privacy or privileges as an employee because of your sexual favor, it is still considered as sexual harassment. Third, the above acts would result in an intimidating, hostile, or offensive environment for the employee. Because you offered a sexual favor, it would create an uncomfortable environment for the employee. Thus, it can already be considered as a sexual harassment. Next slide, please. Next condition is under an education or training environment. So, sexual harassment is committed when first against one who is under the care, custody, or supervision of the offender. Since this is about school, if your teacher, which is you're under custody of, uh, or committed a sexual harassment sa imoa, or it could be anyone who is in supervisor, it can already be considered as sexual harassment even with your consent. Second, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. If like nakay scholarship or anything in ana, tapos in exchange ana is like the sexual favor, it can already be considered as a sexual harassment. Third, when the sexual favor is made a condition to the giving of a passing grade or the granting of honors and scholarship or the payment of a stipend, allowance, or other benefits, privileges, or consideration. So this is what usually happens sa mga students when they have nothing to, like wala na sila sample na sila mga bagsak na grades and they feel like wala na dyan sila chance to like mubawi. They often go to this like option nga mo if naay mag-offer pod sa ilag yung mga inani nga favor, ila na lang dawaton for like a passing grade or like honors, scholarship, and other opportunities. Lastly, when the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. So, pareha sa gimension ganiya sa workers, if maka-create nag uncomfortable environment for the student even though wala pa na dayon ang sexual harassment or gi-reject siya sa victim, it can still be considered as sexual harassment because you made the victim uncomfortable in her or his environment. So, any person who directs or induces another to commit any act of sexual harassment has herein defined or who cooperates in the commission thereof by another without which it would not have been committed shall also be held liable under this act. So this means nga anyone who helps the uh, harasser, even if like accessory lang siya sa crime, or if balag dili siya crime, if gihelp niya ang harasser, they can also be held liable under the act. They can also be uh, held liable under the Sexual Harassment Act or the Republic Act itself. So, working within premise provided by Republic Act 7877, as a response, nagbuhat pod ang Civil Service Commission og their own resolution number. It is Administrative Disciplinary Rules on Sexual Harassment Cases on May 21, 2001. This is a feedback para atong nga Republic Act to strengthen the law even more para sa protection pod sa mga workers. In the CSC resolution, they give even more precise and detailed definition of what sexual harassment is. To know more about this, Laline is gonna report about the section 3 of the said resolution.
So let us proceed. So Anti-Sexual Harassment Act of 1995, Republic Act number 7877, Section 3B also states that for the purpose of these rules, the administrative offense of sexual harassment is an act or a series of acts involving any unwelcome sexual advance, request, or demand for a sexual favor or other verbal or physical behavior of a sexual nature committed by a government employee or official in a work-related, training, or education-related environment of the person complained of. So what is sexual harassment? So sexual harassment is any form of unwelcome sexual behavior that is offensive, humiliating, or intimidating. So as shown in the picture, there are possible offenders of sexual harassment. So sexual harassment is committed by an employee, as what Hayana said a while ago, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who has these three: authority, influence, and moral ascendancy. And when we talk about ascendancy, it is governing or controlling influence over another in a work or trading or education environment. O ito ay sa pilitang paghingi, paghiling o pag-uutos ng sexual na pabor mula sa iba. Ito man ay tanggapin o hindi ng biktima na nanggagaling sa sino mang may kapangyarihan sa loob ng trabaho. So whether accepted or not by the victim, as long as there is sexual favor. And when we say about sexual favor, it is a demand, request, or requirement. So ato nang i-discuss later. So as I mentioned earlier in section 3, pwede siya verbal, but of course, it is related about this sex or sexual favors. If it is unwanted, improper, offensive towards the victim, or humiliating, na makafeel og kaulaw ang biktima because the accused is injuring his or her dignity and self-respect publicly. Let us proceed to work-related sexual harassment. So, for example, the situation. Example, a sexual favor is a condition or hiring that can be called as quid pro quo, or this for that, this for that. So an employer will hire you, but there are some conditions relating sexual favors or promotion in return for sexual favors. So, but when the victim refused to grab it or accept it, i-demote siya or dili i-hire or tanggalin sa trabaho, it is already a sexual harassment, meaning the victim's the victim's refusal or acceptance of the behavior influences decisions concerning her employment. So another situation, for example, is dilipad na diri ha. Example lang is if there's another staff or an employee na like sip-sip sa employer or boss, like acting like a protagonist sa iyang boss who encourages sexual favors or ginapush niya na like, sir, gwapa atong secretary, sir, oh, hipuan mo yan, and so on, then he is already included sa special crime na sexual harassment. And pwede sad nga, if ikaw ang boss, tapos may nagsumbong sa'yo na may nagganap na sexual harassment at wala kang ginawa, you're liable for damages because our law states that the employer shall be solidarily liable. And of course, our law also states that a person who is criminally liable is also civilly liable. But katong boss na walay gihimong aksyon na kabalo siya nga nanay sexual harassment na naganap sa iyang company or office, he or she may not be criminally liable, but he is still civilly liable for damages because he or she has an obligation as employer. So add on lang, and remember, ang accused or victim is pwede babae o lalaki because wala nag-ingon, wala nag-mention ang law about gender. Though we all know na most of these cases is girl ang victim. But as long as it has authority, influence, or moral ascendancy. And in addition, if employee to employee, like wala siya aning tulo, like pareha mong level, dili na siya sexual harassment. It is already another case na acts of lasciviousness. Crime on revised penal code na good faith is a defense. Meaning, dili pwede nga verbal lang, dapat na ay kunting kibo to be considered as acts of lasciviousness. So, let us proceed to educational environment. or sa training institutions. Uh, in educational environment, same ra sila sa work-related environment. The only difference is ang benefits. What I mean is, for example, in school, a teacher or professor or coach nimo sa training is nag-demand or in exchange para makapasar ka or para mas mutaas imong grado is you have to do this, like sexual favors. Of course, sexual harassment na siya. Or himuon ka og honor, cum laude, valedictorian, or any basta na ay demand, request, requirement na para makuha na nimo imong gusto, it is sexual harassment. Basta remember na ay authority, influence, and moral ascendancy. But if you ask, what if kamag-anak? It is another case also. Sexual harassment is only applicable to work and educational environment or in training institution. Basta na authority, influence, and moral ascendancy. So, that's it. So, next.
The content of Section 4 is the place where the offender accused sexual harassment. Number 1. In the premises of the workplace or office or of the school or training institution. For example, you are in the vicinity of your company or even school because it is your working hour or class hour. Number 2. In the place where the parties were found as a result of work or education or training responsibilities or relation. Example for that is kanang your boss is having his blowout party because of achieving something. Di ba naibalutan na ang drinking alcoholic drinks will change the mindset of individual. So diha gid mahitabo ang harassment. Or even sa school kanang naay pa blowout party ang inyong teacher because of winning contest. Maybe some of the students or shall we say offender na makalaong sila og kanang it is just an accidental pero tinuyo gid to. Number 3. At work or education or training related social functions like naay mga training about sa imong field or sa inyong company to make it grow or to make it improve. Number 4. While an official business outside the office or school or training institution or during work or school or training related travels. For example, your boss is appointing someone or even you to attend seminars outside the country kay 'di ba if grow na ang company 'di ba na ay mga seminars outside the country or even outside the kuanra kanang outside the municipality or city. Number 5. At official conferences, fora, symposia, or training sessions. Or number 6, by telephone, cellular phone, fax machine, or electronic mail. For example, offender calls you via messenger or call jud or nagsend og mga sensitive pictures or threats via email. Kay di ba karon na panahon or kay uso na kaayo ang sending mga sensitive pictures to blackmail a victim. To specifically emphasize the effort to identify acts or behavioral manifestation that is construed as constituting harassment, the CEC resolution in its Section 5 identified illustrative form of sexual harassment. Thus, Section 5. The following are illustrative form of sexual harassment. Letter A. Physical. Kanang ang offender is using physical aspect like hands or anything na using his body. Maapil diriya ang malicious touching or holding your shoulder or holding any parts of your body is also part sa malicious touching. Even butt slapping is part of malicious touching. Number 2. Overt sexual advances. For example, the offender kanang he or she is getting closer to you tapos kanang you are not happy with that or you are being forced to have sex or something by the offender. And lastly, na maapil sa physical is kanang gesture with lewd insinuation. For example, offender sent you gestures. Sa letter B is verbal. This includes sexual favor like offender asks you to have sex. Maapil po diri ang catcalling na kanang ginahimo sa mga tambay when there is something na appealing sa ila like makita og girls or something like that. There are many cases of that and pwede sila makasuhan if the one being abused is or will report to the authority. Letter C, use of object. Like most mga reported cases about sexual harassment is sending sensitive photos or picture pero there are also some cases na message or notra. This is also a form of sexual harassment or the any other form analogous to the foregoing. Any worker, student, or trainee or anybody who has been subjected to sexual harassment would have to follow the procedural requirements in filing the necessary complaint. To this effect, Section 12 of the CSC resolution provides, which will be discussed by the next reporter.
Good day, everyone. I am Hayana Tahir, again reporting about the Sexual 12 or the complaint. So, after learning about the different illustrative forms of sexual harassment, we should now proceed to the complaint. I think kani siyang nga process is very essential or very important because I think kailangan jud din nato mabalaan, especially us students, because I'm not saying nakita mo yung pinaka-vulnerable, but in terms of like the confident to report such things, I think ang students mo yung pinaka ma-overcome of fear when it comes to sexual harassment. So I think every one of us, boys or girls, must know the process of the proper filling up of complaint. Next slide, please. So first, the complaint may be filed at any time with the disciplining authority of the office or agency or with the Committee on Decorum and Investigation. Upon receipt of the complaint by the disciplining authority of the office or agency, the same shall be transmitted to the Committee on Decorum and Investigation if there is any. In the absence of a Committee on Decorum and Investigation, the head office or agency shall immediately cause the creation of Committee on Decorum and Investigation in accordance with the law and rules and transmit the complaint to the committee. So if ever you experience like sexual harassment in any form, like parehas sa mention ni Lalin a while ago, if verbal man siya or physical, and you plan to like file a report, complaint about it, first ang pinakauna nimo duulan is ang pinaka near nga disciplining authority or office. If naka sa school, you can report it to the guidance, or mas duol pa is your teacher itself. But if naka sa work, it can be your boss. If your boss ang mismo gabuhat atong sexual harassment, pwede ka mo diretso na dayon sa Committee on Decorum and Investigation. Like what pare sa school, if like ang imong guidance counselor, if ever nga ang mag-harass nimo is like something or someone nga of a higher position, tapos nagpasa kag complaint sa ila, and if ever dili to nila idiretso sa Committee on Decorum and Investigation, they will also be held liable to it because gi-restrain nila ang complaint. So murag na sila, if ever nga murag gi-try nila protect ilang katong someone nga nasa higher position, pwede po sila ma-held liable ato. But first, what is this Committee on Decorum and Investigation? So mao ni sila mo'y assign nga mo receive and investigate complaints on sexual harassment cases. Next slide, please. So the complaint must be in writing, signed and sworn to by the complaint must be in writing, signed and sworn to by the complainant, and it shall contain the following. First, the full name and address of the complainant. Second, the full name, address, and position of the respondent. Three, a brief statement of the relevant facts. Four, evidence in support of the complainant, if any. Five, a certification of non-forum shopping. So, ang complainant, after niya mag-file, of course, na siya mga sa iyang file na siya mga ibusulat niya itong mga important details about the said act. So first is the full name and address of the complainant. Isulat niya yung full name and address. Second, the full name, address, and position of the respondent or katong nag nagbuhat og sexual harassment. Like for example, if in any cases nga murag wala ka kay lato niya or something like that, you should tell kung unsa, or you should include kung asa to siya nahitabo, or any other facts that will help the investigation find the harasser. Three, a brief statement of the relevant facts. So, like the time, if kabalo ka, ang address, or unsa ba kung naba kay relationship atong harasser. Four, evidence in support of the complainant, if any. So, if any case nga maabot na siya like rape or anything nga grabe na kanang murag something na nga ni dangerous, kailangan nimo mag-present og evidence if na kay mga evidence, like for example medical legal or anything nga pwede mo support sa imong mga statements. Lastly, a certification of non-forum shopping. Kaning certification of non-forum shopping, kani siya ay certification under oath. Nga example, if naa na daay mga issues about ato tas nag-complaint na kadaan, makita to siya sa certification of non-forum shopping. Or if any case nga nanay pending daan nga cases kung imong gireklamo or anything like that, and or if like nakareklamo na kag kapila tapos kato nanay pending daan, makita na siya sa certification of non-forum shopping. So, in the absence of any one of the aforementioned requirements, the complaint shall be dismissed without prejudice to its refiling. So, if nakay nang naay essential part ana nga imong ma-miss, like for example ang imo lang gibutang is imong name o ang name sa atong nag-harass nimo, if kabalo ka or kaila ka niya, that would not be enough for the investigation to like to find or to investigate kung sexual harassment ba to siya, and then your complaint will immediately be dismissed. Where the complaint is not under oath, the complainant shall be summoned by the committee to swear to the truth of the allegation in the complaint. So, maora to. And I think we should all really remember the steps o kung asa ta mag-complain or mag-report nga pinakaduol when it comes to things like this, because again, importante ni siya sa tanan and moto. So, the next reporter is Lalene.
Letter C, complaints sent by telegram, radiogram, electronic mail, or similar means of communication shall be considered non-filed unless the complainant shall comply with the requirements provided in Section 12B within 10 days from receipt of the notice for compliance. So if ang complainant is nag-file siya through telegram, radiogram, electronic mail, and many more, is accepted ra siya if gi-comply to niya ang mga informations na relevant informations na provided sa Section 12B. Like katong gi-report ni Hayana na ang full name and address of the complainant, the full name, address, and position of the respondent, a brief statement of the relevant facts, evidence in support of the complainant, if any, a certification of non-forum shopping. So letter D is the withdrawal of the complaint at any stage of the proceedings shall not preclude the committee from proceeding with the investigation where there is obvious truth or merit to the allegations in the complaint, or where there is the commentary or direct evidence that can prove the guilt of the person complained of. So, kining letter D is if kuntahay ang complainant is nahuna, gusto niya i-withdraw ang iya ang file nga case against the offender or sexual harasser, is if makita gali sa investigator na obvious na is kanang naanay sapat na ebidensya nga napakita gid sa complainant na tinuod iyang gipang-ingon, is dili siya maka-prevent sa committee nga ma-stop ang investigation, kung dili mapadayon gihapon ang investigasyon nga gibuhat sa offender. So that's it.
And now let's talk about Section 53 of Anti-Sexual Harassment Law. So in this section, this includes the sexual harassment, the classification of sexual harassment as grave, less grave, and light offenses. Grave offenses shall include but are not limited to unwanted touching of private parts of the body, genitalia, buttocks, and breasts, sexual assault, malicious touching, requesting for sexual favor in exchange for employment, promotion, local or foreign travels, favorable working conditions, or assignments, a passing grade, the granting of honors or scholarship, or the grant of benefits or payment of a stipend or allowance, and other analogous cases. Next, the less grave offenses shall include but are not limited to unwanted touching or brushing against a victim's body, pinching not falling under grave offenses, derogatory or degrading remarks or innuendos directed toward the members of one's sex or one's sexual orientations or used to describe a person. 4. Verbal abuse with sexual overtones and other analogous cases. For light grave offenses shall include but are not limited to surreptitiously looking or staring a look of a person's private part or worn undergarments, telling sexist smutty jokes or sending this through text, electronic mail or other similar means causing embarrassment or offense and carried out after the offender has been advised nature, clearly embarrassing, offensive, or vulgar. Malicious leering or ogling, the display of sexually offensive pictures, materials, or graffiti. Unwelcome inquiries or comments about a person's sex life, unwelcome sexual flirtations, advances, propositions, making offensive hand or body gestures at an employee, persistent toward attention with sexual overtones, unwelcome phone calls with sexual overtones causing discomfort, embarrassment, offense, or insult to the receiver, and lastly, other analogous cases. Section 54. The head of office who fails to act within 15 days from receipt of any complaint for sexual harassment properly filed against any employee in that office shall be charged with neglect of duty. So for example, you are a person that is assigned of to act in the complaints like 15 days na nag-complaint ang imong employee tas pagkahuman wala nimo siya gimuan og action so pwede ka nga i-charge og neglect of duty. And then section 55, any person who is found guilty of sexual harassment shall after the investigation be meted the penalty corresponding to the gravity and seriousness of the offense. So kada kung ikaw is a suspect of sexual harassment, so naa kay mga consequence, imo nang harapon ang consequence sa imong actions pero depende sa imong actions magdepend sa imong gibuhat ang imong madawat nga kuan mga penalty. Next, section 56. So in these sections we can classify the corresponding penalty. The penalties for light, less grave, and grave offenses are as follows. For light offenses, first offense reprimand, like warning. Second offense, fine or suspension not exceeding 30 days. So pwede ka magbayad or ma masuspend sa imong work for 30 days. Third offense, dismissal. For less grave offenses, first offense, fine or suspensions of not less than 30 days and not exceeding 6 months. Second offense, dismissal. For grave offenses, dismissal. Next, Section 57. If the respondent is found guilty of two or more charges or counts, the penalty to be imposed should be that corresponding to the most serious charge or count, and the rest shall be considered as aggravating circumstances. So, pag ikaw is a suspect with two or more charges or cases, the penalty to be imposed should be kanang pinaka-serious na siya nga charge sa tanan. Next, the function of the said committee is to receive complaints of sexual harassment. Second, investigate sexual harassment complaints in accordance with the prescribed procedure. Third, submit a report of its finding with the corresponding recommendations to the disciplining authority for decision. Fourth, lead in the sexual of discussions about sexual harassment within the agency or institution to increase understanding and prevent incidents of sexual harassment. Lastly, sexual harassment as an offense is not only about sex, it is about power, relationships between the offender and the victim. Thus, potential offenders are those having authority, influence, and moral ascendancy over their victims. That's all, the end of report of Group 10. Thank you.
All right. With that being said, we now conclude our reporting about anti-sexual harassment law. We are now open for questions and clarifications from the students. If none, thank you so much for listening and God bless.